So thank you for attending the presentation. What I would like to cover is really just a comparison of the Arizona Medical Marijuana Act, which has been in law in Arizona for about the last 10 years, and the Smart and Safe Arizona Act, which is the voter initiative that will be on the ballot on November 3rd, most likely. So I'll be running through a comparison of the various aspects of the existing law, and then also the law that the voters will be weighing in on in November. So let's just cover the basics first. Most of you know a lot about the Arizona Medical Marijuana Act, but I'll cover it briefly for those of you that aren't as familiar with it. So in the Arizona Medical Marijuana Act, anybody who has a certified patient card that is issued by the Arizona Department of Health Services can go into a dispensary and buy as much as 2.5 ounces of marijuana every 2 weeks for their medical condition. They have to buy a card from the state. Those cards cost $150 and they last 2 years. So essentially $75 a year. There's a discount for people that are on this, the SNAP program. The products are available only at dispensaries. However, there's an exemption. Those patients that live more than 25 miles from a dispensary can grow 12 of their own plants. Also, there's a provision in place under the Arizona Medical Marijuana Act where people can have a certified caregiver that can help them and grow their plants for them as a designated caregiver. The Smart and Safe Voter Initiative is a little bit different from that, obviously. If it passes, if the voters approve it, marijuana would be available to any adult 21 years and over who can establish their age. So it's not available to children. No medical marijuana card and no ID card of any sort is needed except to establish that you're 21 years old. So it's a lot like buying alcohol in that way. And there is no administrative fee. So as I mentioned, the Medical Marijuana Act has an administrative fee of $150 for a 2-year card. There's no administrative fee associated with the Smart and Safe Arizona Act should it pass and get implemented by the state health department. So how do you get the marijuana? So it's pretty straightforward with under both programs. Under the Arizona Medical Marijuana Act that's existing, qualified patients can buy marijuana at state licensed dispensaries. There's roughly 120, 130 of those dispensaries existing across the state. Patients can get their marijuana from a caregiver for free if they have a caregiver. Again, those caregivers generally will grow the plants for their patients. Patients can receive marijuana for free from other patients. That was written into the voter approved law, so people can give it to one another. The number of dispensaries is limited to 10% of the number of pharmacies in the state. So that's roughly about 140 as a maximum. So that's the maximum cap within the Arizona Medical Marijuana Act. For the Smart and Safe Arizona Voter Initiative, which is on the ballot November 3rd, anybody 21 and over can buy 1 ounce of marijuana or 5 grams of extract at any trip to the dispensary. So with the Medical Marijuana Act, you can have up to 2.5 ounces that you can buy every 2 weeks. Under the Smart and Safe Arizona Act, you can buy up to 1 ounce at the dispensary, and that's your cap, or 5 grams of extract. But the state is not going to track your purchases. So you could go to one dispensary, get 1 ounce, go to another dispensary, get another ounce, get another dispensary, get another ounce. And that's totally okay to do for the dispensaries to sell that to you. The problem is, and we'll get to that later in the presentation, that the criminal penalties are only waived for up to 1 ounce of marijuana. So if you buy more than 1 ounce by going to different dispensaries, you will be, if you get caught and you don't have a medical marijuana card, you could get charged with a Class 6 felony, just as you would today. Every adult over 21 and over can grow 12 plants of their own. So this is if the act passes. You can go 12 of your own plants in your house. You can't grow it out in public where kids can get it and so forth. It needs to be enclosed. You can grow up to 12 per household. So let's say you have 4 college students living in a house, and they want to grow their own marijuana. They could grow up to 12 total. So it's not like they could grow 24 with 4 roommates. It's capped at 12. In terms of the establishments, I'm not going to call them dispensaries. They're basically retail stores. They too are limited to 10% of the number of pharmacies. There's a couple of exceptions to that, but really you're looking at the same number of stores that you have dispensaries today. And under the Smart Safe Voter Initiative, the existing medical marijuana dispensaries would, over the course of a year, transition into retail marijuana establishments. So there's no real action that's needed specifically to take administratively. The state health department the Department of Health Services would oversee this if it passes. DHS would create their own regulations and rules. And so it could be that the rules for retail stores are slightly different from the medical marijuana dispensaries. And so in that regard, the new stores would need to come into compliance with the new regulations, but essentially they don't have to go through the same random selection or selection process that we used when I was running at the state health department back in 2010. We used a random selection system to select those folks that were successful applicants. All that will be avoided with the retail marijuana law because, as I mentioned, the existing dispensaries simply transition to the new form. So how about local control? Really not much difference at all. The Arizona Medical Marijuana Act allows local jurisdictions, that's cities and counties, especially cities, planning and zoning, to put regulations in place about where dispensaries can be licensed. They have to be reasonable regulations. They are not allowed to put unreasonable regulations in place. And there's court case law to establish what reasonable actually means. But that's the situation there. Same thing with the Smart and Safe Voter Initiative. Now, here's the thing: is, as I mentioned, the existing medical marijuana dispensaries can transition into retail stores if this passes, and so the zoning and planning part of this is really not that much different. Although, a city could decide that while they were willing to tolerate a medical marijuana dispensary in a certain zoning area, they may not want to tolerate a retail store. And so depending on what the city decides, they could make some different decisions. Again, the license would still transfer to the retail store from the medical marijuana dispensary, but local control still applies in both cases. So let's talk about possession of cannabis a bit. I covered some of this on an earlier slide, but this is really important. I want to cover this again. So on medical marijuana dispensaries, patients can have up to 2.5 ounces of marijuana that they bought at their dispensary. Beyond 2.5 ounces, it's a Class 6 felony. So if you have a card today, you can have up to 2.5 ounces, but that's it. It is available to kids, so kids under 21. 18 can have medical marijuana cards, and parents have to weigh in on that, because they're minor children and so forth. But that provision is available, and there were a number of children who are medical marijuana patients in Arizona. The products are available only at dispensaries to card holders. Again, there's an exception. You can grow your own plants up to a limit of 12 per patient if you live more than 25 miles from a dispensary. Under the voter initiative that will be coming onto the ballot in November, cannabis is available to any adult over 21, but no kids. And by kids, I mean anyone under 21. So if you're 18, 19, and 20, in some respects of the law, you're an adult. For the purposes of the retail marijuana voter initiative, you will not be an adult. It's like alcohol, sort of. Adults over 21 can possess up to 1 ounce or 5 grams, and I talked about that earlier, or 6 plants. But beyond that, there are no legal protections for that person. So if you, like I said, if you're planning to go out of town and you buy more than 1 ounce and you have that in your possession, the act will not protect you from prosecution from zealous prosecutors. So that's still in place. Again, no medical marijuana cards are necessary. If this retail law passes, you could just go into a store and buy them. You have to establish you're 21, but that's it. And there is no administrative fee. Remember, with the medical marijuana program, there is that administrative fee for both getting the card from the state and actually the physicians who sign certifications often, I think all of them charge a fee. It depends. Some charge about $100 fee, but again, is not something that will be in place if the retail law passes. Okay, let's talk about criminal penalties for a sec. I touched on these, but let's go into some more detail. It's a felony offense in Arizona, even if you have a medical marijuana card. Let me put it this way. If you have a medical marijuana card, you can have up to 2.5 ounces of marijuana. If you don't have a card, any amount, even 1/2 of 1 joint, is a class 6 felony, and people have been prosecuted for that and have done time. And even if they don't do time, they get entrenched in the criminal justice system, have to pay all the fees. They probably have to take a course that they need to pay for from usually Task or some other entity. So medical marijuana program is a protection in place, but you need to comply with the provisions of that law. Under the voter initiative that's on the ballot in November, adults can possess less than 1 ounce. If they possess, and I mentioned, I just said it's a penalty for having more than 1 ounce. I think I may have even earlier said it was a felony for more than 1 ounce, but that's not exactly true. It's between 1 ounce and 2.5 ounces would be a petty offense. So essentially like littering, something like that. So under 1 ounce, no penalties whatsoever if you're 21. If you have between 1 ounce and 2.5 ounces, it would be a petty offense if you get caught, something like littering. But if you have more than 2 ounces, 2.5 ounces, you would be subject to the regular criminal code as it exists today, even though you bought it at a retail store. So the amount that you have will really matter if this passes. Not so much under 2.5 ounces because a petty offense isn't very strict. But over 2.5 ounces, you may, there could be some people that believe the law provides more protection than it actually does. Because again, over 2.5 ounces, you're in the pokey. Persons under 21, so let's cover minors, or I guess some of these aren't minors, but people under 21. So people under 21 that have less than 1 ounce is only a $100 fine. So this, I could see some people thinking that, and I have some reservations about this myself, straw buying would be pretty easy if somebody over 21 wants to give marijuana to someone under 21, and that person who's under 21 only has to pay a $100 fine. I mean, that's, and it's not a criminal offense, so that's not a very big penalty. The second offense is a petty offense, so that's not very serious either. A third offense is only a class 1 misdemeanor. So if for people under 21 who possess more than up to, or in the 1 ounce area, penalties are not really very strict, or won't be. It's not law yet. Impairment. Let's cover that for a sec. So the Arizona Medical Marijuana Act prohibits, there's no protection whether you have a card or not. You're not allowed to drive while you're impaired, regardless if you're a card holder, that doesn't matter. That's impaired driving, just like it is with alcohol or anything else. And penalties are pretty severe for that, as they should be, because you're putting other people's lives at risk when you do that. Employers can require impairment-free workplaces under the Smoke-Free Arizona Act. So if you have a medical marijuana card and you work at a warehouse or whatever, your employer can require that you be impaired, that you not be impaired, an impairment-free workplace. And so that's, there's no protections for that under the Medical Marijuana Act for individuals. There are for businesses. And public smoking of marijuana is not allowed. And there's a definition of public places that are that's built into the regulations that we developed when I was at the state health department. Those are still in place. Smart and Safe Voter Initiative, same thing, illegal to drive while impaired. That doesn't change. Employers can require a impairment-free workplace, so that doesn't change. That's the law now, even for medical marijuana patients. And public smoking of marijuana is not allowed. Now, the state health department is the entity that's going to have to write the regulations and rules for this. And, they may elect to put in a different definition of public smoking than we used for the Medical Marijuana Act. There's new leadership over there now. They may not agree with what we put in forward back in 2010. But my sense is they will keep it the same, because otherwise you are putting a situation in where public smoking is different for patients versus just people over 21 in terms of the definition of what's a public place. And by the way, what we did is we tied the medical marijuana law or regulations to the Smoke-Free Arizona Act. So we piggybacked on what had been developed in 2006 for that law. Product characteristics, packaging, labeling requirements apply. So, the original rules for the Medical Marijuana Act had some packaging and labeling requirements that applied. We put those in place, and they have been revised over time because of statutes that the legislature has passed that have required the state health departments to make some modifications to that. Last or two legislative sessions ago, not this last session, which was the COVID-19 session, but the one before that, a bill passed requiring the state health department to come up with potency and quality testing. And I know they're working on those regulations now. And perhaps they've even promulgated those rules, I'm not sure. But that testing would begin in 2021. Again, that's the Medical Marijuana Act. For the purposes of the Retail Marijuana Act, same thing, Arizona Department of Health Services packaging and labeling requirements would apply. The statute itself that the voters will be voting on in November, and some people early voting in October, the statute there's standards that the state must use when they write those regulations. Interestingly, the voter initiative in November has a potency limit of 10 milligram doses. So that would be for things like edibles, extracts, et cetera. There's a potency limit of 10 milligrams for those more high potency type of products that would be available in the retail stores. And then, testing for contamination would be decided by the Arizona Department of Health Services by regulation. So they'll be putting those regulations in place should this pass. And that would be for testing, packaging, labeling, et cetera. My sense is that they will do their best to align the requirements with the medical marijuana program to avoid regulatory confusion and confusion for their inspectors and for the public, but I'm not there anymore, so I can't really say what exactly they're going to do if it passes. Okay, let's talk about the money for a bit. So the medical marijuana program is funded largely by fees that the department charges to patients as they buy their cards. For many years, the price of the cards was $150 per year, $75 for those people on SNAP, food stamp program. And those were only good for 1 year. Those are good now for 2 years, which is as a result of a law passed by the legislature and signed by the governor. When I set those fees, I say I was the head of the department at the time. It's my fault that the fees were too high. I mean, they were just way, way, way too high. I didn't anticipate that there would be, north of 160,000 patients in the program. I thought we'd be tighter than that, and we'd have 30,000 or so. As a result, there's at least an $80 million fund at the Department of Health Services, which is an accumulation of the fees that patients have paid over time. Those fees, those funds are held by the Arizona Department of Health Services. They can't be used for other purposes nor swept by the legislature. So the purpose for that medical marijuana fund was to regulate the program. So it pays for the inspectors and any the things that you would need to operate the program, servers and the like. But again, I set the fees too high, which is why there's way too much money in the fund. So what would happen if the retail marijuana program passed on November 3rd? Well, immediately it would transfer the money in the medical marijuana fund to the new fund for the Smart and Safe Voter Initiative. There would be, it would be transferred in the following, not all of it would be transferred, but the following things would happen. $15 million would immediately go to the Arizona Teachers Academy. That's a program to help support tuition and so forth for teachers, aspiring teachers in the university system. $10 million would go to the Arizona Department of Health Services other programs, so other public health prevention type programs. And then 10 million of the existing 80 million, maybe it's even 100 million now, I don't know, would go to the governor's highway fund. So there would be an immediate transfer of 10, 20, $35 million from the fund to those areas, but the Arizona Medical Marijuana Fund would maintain all the money that above and beyond that 35,000 for the time being. I won't cover the Arizona Medical Marijuana Act about the future money because that doesn't change with this. So if the retail marijuana law passes, then there'd be sales taxes collected on the retail marijuana products, the flower or the edibles and so forth. There'd be a 31% of that tax would go to community colleges. 31% of that tax would go to police departments across the state, and 30% would go to the Department of Transportation's highway fund. So you could see that adds up to 92%. I don't know what happens to the rest of that 9%. Maybe it is retained by the department to operate the program. I'm not sure. I should know that, but I don't. So let's do a quick comparison of the two. We've already covered this, but I want to cover it again. Well, some of this I've covered. Qualified patients under the medical marijuana program are protected from prosecution for having marijuana as long as they have less than 2.5 ounces of flower and a prorated amount of extract or resin. But if they have a previous conviction, let's say a patient has a card and they got that card and let's say they're 35 years old and they got that card when they're 35 and they had a conviction of a marijuana possession, and maybe it was for their medical condition, whatever, 10 years ago, let's say, or 5 years ago, whatever. There is no expungement provision in place for those patients. They still have that criminal conviction on their record. If the Smart and Safe Voter Initiative passes, people with convictions, previous convictions for possessing up to an ounce of marijuana flower, that's the buds essentially, or 5 grams of extract, or 6 or fewer plants, can apply for an expungement of their previous conviction. Now, if they were charged with and convicted of possession of, say, 3 ounces or 2 ounces or whatever, no, you can't get an expungement for that. But if your original conviction was for an ounce or less, you could apply for expungement. And the good news is, at least I see this as good news, because one of the reasons I still don't know how I'm going to vote on this. The reason I'm leaning towards voting for it is because of the criminal justice reform provisions that are built into this. And that's what I'm talking about specifically now. The court must grant the expungement unless they find clear and convincing evidence that the person doesn't qualify. So it's supposed to be basically automatic, but you have to apply. So there are some states that have retail laws that are where there's an automatic expungement. That's not the case here. The person with the previous conviction would need to go to the court, apply for the expungement, but the court can't, in an arbitrary or capricious way, decline that expungement. They are required to do that unless there's clear and convincing evidence that they don't qualify, and there's a legal standard for that. So I don't expect people too much cheating to happen on that, but you never know. I've been surprised over the years about what prosecutors are willing to do. So in terms of implementing the program, I'll do a little history lesson on the first part of this. on the Arizona Medical Marijuana Act, if you can remember back to 2010 or 2011, when we were implementing the law, there was some consternation with the then Attorney General, Tom Horn, who suggested that it would be a felony for me as the director to issue dispensary licenses to applicants, even though the Medical Marijuana Act was approved by the voters. I never was concerned about that, and I got a letter from Dennis Burke, who's the U.S. attorney at the time, and he was never concerned about that. But nevertheless, there you have it. It delayed the implementation of the program for quite some time, really almost a whole year for the dispensary part of it, until Governor Brewer, at her direction, I was able to go ahead and issue those dispensary licenses. And so there's a provision in place under the Smart and Safe Voter Initiative, and I think perhaps it's in there because of what happened with the implementation of the Medical Marijuana Act with regard to the dispensaries. But there's a mandamus action authority if the state health department refuses to implement the law. So what mandamus means is that, let's say this passes and the state health department, whoever this director at the time, decides, well, you know what, I'm not going to do it. Pound sand. I'm not going to implement this. Well, if they do that, then there's mandamus authority, so that anybody, any citizen of the U.S. who's be over 21, because you have to have standing, could sue in court and get the court to order the state to implement the program. And if the director then still refuses to do that, then it's a violation of court order, and then you could get in big trouble for that. And there's no, it'd be in big trouble if that happened. So don't know. I mean, who knows? Maybe there won't be any issues like that we had, with the medical marijuana program. But if there is, there's a mandamus provision in place. So that it roughly sort of closes out my main part of this presentation. Again, I hope to be doing this live. But if you're seeing this, then something happened and I couldn't do it live. And that's why I'll say, the Arizona Department of Health Services, the Arizona Public Health Association, who I'm the executive director for that organization, we had a series of 4 different groups of interns who did a analysis of the Smart and Safe Arizona Act that really looked into the public health risks and benefits of the program. That literature review and those reports are up on our website under our Public Health Policy Committee part of our website. I'll be blogging about that later on in the year. I'm going to wait and really sort of do that in September and October. But you can look at that. There, some of those have a gap analysis between this voter initiative and what is expected under the American Public Health Association's policy statement from retail marijuana programs and so forth. It goes into the criminal justice reform provisions of the act. It goes into the details of the regular retail marijuana law, et cetera. So that's available on our website, and our intention is that hopefully some voters will take advantage of that information and learn a little bit more before they cast their vote. Here's the information here. This is how you can become a member of the Arizona Public Health Association. We have some member benefits, including policy updates that I do every week. I try to tie in things that people are really interested in, et cetera. You can become a member at azpha.org for more information. It's just, as I said, $75 a year, $25 for students. So thank you for your attention.